Donald Trump has been criminally indicted for his willful retention of national defense information, false statements, conspiracy, and obstruction of justice in federal court in the Southern District of Florida by a grand jury there in a powerful, detailed speaking indictment with 38 criminal counts. Special counsel Jack Smith lays out the case against criminal defendant Donald Trump and his criminal co-defendant and personal aide Walt Nauta. The criminal indictment contains photographs of boxes with highly classified information in bathrooms, on the floor, in auditoriums, all totally unsecured. The indictment contains text messages from Trump's employees like Walt Nauta and others, showing Donald Trump was directly involved at every step in trying to deceive the FBI and the Department of Justice by trying to keep these classified records. The indictment also includes under oath testimony from witnesses against Donald Trump, and it quotes audio recordings of Donald Trump showing classified documents to people and bragging about it. Donald Trump will be criminally arraigned in a Miami federal courthouse this Tuesday, and already Donald Trump and groups like the Proud Boys and other right-wing extremists are trying to incite violence in front of the courthouse. Meanwhile, Donald Trump's lawyers, Jim Trusty and John Rowley, who led his legal defense in connection with special counsel Jack Smith's criminal investigation into Trump's theft of these government records, have officially left the legal team. But get this, the case against Donald Trump has been randomly assigned to disgraced federal judge Eileen Cannon from the Southern District of Florida, a 2020 Trump appointee who we all know because she was previously reprimanded by the 11th Circuit Court of Appeals not once, but twice for improperly asserting jurisdiction for Donald Trump over the Department of Justice's search warrant executed at Mar-a-Lago last year. We will break down all aspects of this criminal indictment and what happens next. Also, let's not forget that special counsel Jack Smith has another criminal investigation still taking place of Donald Trump relating to the January 6th insurrection and Donald Trump's attempt to overthrow our government and destroy our democracy. And Jack Smith is moving closer to another criminal indictment in that matter. On Friday, the federal judge presiding over that grand jury in Washington, D.C., partially unsealed his order from March when he compelled former Vice President Mike Pence to testify before the grand jury. And when you read this order, it also shows how very, very damaging the evidence is against Donald Trump in that matter. A historic episode of Legal AF, and no other way to do this when with both co-hosts, Michael Popok and Karen Friedman Agnifilo. How are you doing both? Popok, how are you doing?
I'm doing great. Proud to be an attorney, an American, a patriot, and a part of the justice system in my own way. And here with you and Karen to unpack it all. We've done it in hot takes, kind of on the fly, but this is our first opportunity together to analyze what's happened, talk about things that are agitating our listeners and followers, hopefully give them some remedy, some balm for that, and then talk about what's going to happen next with Tuesday's arraignment. Hi, Karen.
Karen, how are you?
Hello. I'm good. Thanks for letting me join. I'm excited about it.
Always, not only is it an honor when you join, but it adds extra delight to these weekend Legal AFs when the gang is all here together. But let's dive right into it. First, let's talk about what this indictment is, when we learned about it, what the various counts are, 38 counts, what the charges are. Let's just break down, Michael Popok, what is actually in this indictment. I laid out in very broad terms what's in there, but let me pass it to you.
Great. I'll do that then. And secondly, I do want to address the elephant in the room, no pun intended, with the GOP, Eileen Cannon being assigned. I have a different theory about what may happen on Tuesday, and I will share it and analyze it here. But I'll tease that, but let's get back to what you asked me. I'm going to give two keys, K-E-Y, that people can use when they read this indictment. We, of course, have posted it all over, and we'll talk about it at length today. There are 37 counts against Donald Trump, and including some that he shares with Walt Nauta, his valet, butler, body man. It depends on what era you grew up. That was his role from the White House all the way forward to Mar-a-Lago. And one count alone against Walt Nauta for false statement. That gives us a total of 38. The easiest way to group it is, of course, the way the government has grouped it. 31 of those counts are for individual violations of the Espionage Act, document by document by document. That's why there's 31 of them. So there's a list here that we're showing on the screen from the chart within the complaint that shows the 31 times, at least based on current knowledge to the Department of Justice and the grand jury, of times when the Espionage Act, Donald Trump using, secreting, not returning, transmitting national defense information, NDI, which includes as a subset classified and top secret and the highest levels of national security documents that this country owns and possesses, including nuclear, the fighting capacity of our adversaries and of our allies, things that if any of those pieces of paper found their way out of the bathroom, ballroom, storage room, or any other semi-public area of Mar-a-Lago or Bedminster or the airplane or the SUV or all the people's hands who touched it who aren't qualified or to have classified top secret information, this country would be imperiled. That is the gravamen, the foundation of this complaint. And think about how many people. There's 150 people or more that work at Mar-a-Lago. There's another dozens and dozens that work at Bedminster. We know what we know. We know what was returned forcibly by execution of search warrant and a subpoena and a little bit that was dribbled back by Donald Trump to the National Archive back at the very beginning. We don't even know what's missing. We don't know. There has to be a working hypothesis that there are documents that are no longer within the care, custody, and control of even Donald Trump because of the way he carelessly maintained these documents. So that's the breakdown of the 38. It goes across 8 different federal statutes, but I'll give you the big picture on them. You've got conspiracy to obstruct justice, which is what we always thought this was going to be an obstruction case. We talked about frequently in Legal AF, and this was going to be a Espionage Act case. We've been talking about that since day one. Both those counts are there. Both those counts are shared. The conspiracy count is shared with Walt Nauta. He's a co-defendant in that one. The Espionage Act is right now just against Donald Trump himself. Then you've got various counts that sound the same but arise under different federal statutes, concealing documents, a conspiracy to conceal documents, a scheme to conceal documents, and then you have the stuff related to false statement. So what are the false statements? For Donald Trump, it is his efforts to allow, because he misled his lawyers on purpose, Corcoran, and we'll talk about Corcoran, and Bob, who certified under penalty of perjury on June the 2nd, 2022, before the execution of the search warrant, that they had done a diligent search when Trump knew or should have known that at least 30 boxes that he directed be taken out of the storage room remained in his personal residence at Mar-a-Lago, therefore could not have been searched by Corcoran prior to his meeting with the FBI. Trump didn't want them searched. They remained with Donald Trump until after the search was completed, that Trump allowing them to sign that, knowing that they were meeting with the government the next day, that they needed to comply with the subpoena. That is him also participating in a false statement. And then you've got the false statements that Walt Nauta has made independently. And this is, we all speculated the best we could that Walt Nauta was in deep trouble because not only did they have him on video and that's reflected in the complaint by timestamp, moving boxes in and out of the White House, of Mar-a-Lago's various locations, and always ending up in the personal residence section of Mar-a-Lago in the Pine Hall, which is some sort of hallway in front of the bedrooms and the offices that Donald Trump resides in there at Mar-a-Lago, putting Trump right into the jackpot. He's reviewing the boxes that Trump is making the personal decision based on his own personal review about what to spoon feed back to the National Archive at the very beginning of this process when only 15 boxes arrived. Even those had classified documents inside of them. And then Trump coaching his lawyers, Corcoran and Halligan, we'll talk about Lindsay Halligan in a minute, to why don't we say that isn't it better if we tell the government in response to the subpoena that there aren't any documents? Wouldn't that be better? And then using examples that he thinks come out of the Hillary Clinton server era to suggest to them their testimony, to tamper with them, and to obstruct justice. Wouldn't it be better if some of those documents and then he made a plucking, according to Evan Corcoran's notes, which are referenced in the complaint, he made a plucking motion. If they just kind of disappeared when they were in your hotel room, Mr. Corcoran, wouldn't that be good? Or how about that IT person for Hillary Clinton that made a bunch of emails disappear? And he didn't get in trouble. He's telling that story because he's trying to coach his lawyers into obstructing justice with him. And Evan Corcoran takes it all down in his notes. If you're trying to unlock the key of the complaint, Ben, and for our audience, I'll give you some of the names that are obvious. Attorney number one for Trump is obviously Corcoran, who turned over 50 pages of notes and audio tape of his musings and testified to the grand jury. Attorney number two has to be Lindsay Halligan, because Lindsay Halligan was present during the search warrant and during some of the other attempted document collection by Corcoran. And attorney number three has to be Christina Bobb, because she's the one that signed that certification. The other fascinating bombshell, there's so many, I mean, you've done a million hot takes on them, and I could too, that's in the complaint, is that Christina Bobb, without participating at all in the search of even the documents that Donald Trump self-selected for Corcoran to look at, she didn't even participate in that. Corcoran called her up, told her to come over, put a form in front of her, and she signed it, having not looked at the documents and didn't even know there was a subpoena or what was in the subpoena. That was gobsmacking to me. And the other thing that was gobsmacking to me is based on the timestamp. Evan Corcoran spent 35 minutes looking at what was in the storage unit in order to find or not find whatever Donald Trump had placed there for him. You know, this theater that was going on, this kabuki theater for Donald Trump. He spent 35 minutes. I've been doing this a long time. I've gone into a room full of boxes that I've had to search for discovery purposes or because there was a subpoena outstanding, and you can't even order your cup of coffee in 30. How do you review that picture of documents that we've just put on the screen, piled high to the ceiling and wide to the edge of the room in 35 minutes? But he did, because that's what it said. He came in and came out, and they have the timestamp for that. So you have all of that. The other person that you can kind of piece together is there's two instances that are referenced that we talked about on Legal AF, where highly compartmented sensitive information, including what's called the Five Eyes, meaning only 5 of our allies, Canada, Australia, us, and 2 others, can look at New Zealand, can look at this material. It's called Five Eyes material. He was showing Five Eyes material, Donald Trump, at Bedminster, because he secreted documents and boxes through Walt Nauta, got them to Bedminster on his plane, and then was showing them off to people, including Taylor Budowich, who just testified earlier in the week in Miami at the grand jury. That's the guy who's a member of the PAC that got shown at least one of those war maps or war planning documents. That is another violation under the 1 through 31 counts of Espionage Act that is cited. That is ridiculous. And then lastly, there's even a little warning, not only to the people who are like Walt Nauta around Trump, who have not come forward to cooperate with the government. They could be next in being indicted. But you have a reference. It has to be to Melania Trump within the document. Now, they could have left it out because it doesn't really move the ball ahead in terms of the crimes that are being alleged. But there is a reference we put up on the screen. There's only one female member of his family that would be responsible for moving from house to house, and that's Melania. It's not the daughters. It's not anybody else. It's Melania. And you can tell from the way this is written in sort of not English as a first language type language that she's telling Walt Nauta, there's no room on the plane to Bedminster for all the boxes that Donald Trump wants to take with him to get them away from Mar-a-Lago and the prying eyes of the FBI and the Department of Justice. That's Melania. Why is it in there? Because they're sending a shot across the bow to Donald Trump that says nobody is safe. We've got text messages, we've got emails, we've got video, we've got testimony. We got it all. And if you don't play ball with us, and if you think we're not serious, we're putting your wife in there as well. That's my takeaway from where we're at. I want to do one thing on Eileen Cannon, because I have a different view, and I just want to give people a little bit of, I know that this is an agitating issue, that she got, quote unquote, assigned to this. I'm not sure that's going to happen on Tuesday, and I'm not sure she's the permanent judge. I'll tell you why. First of all, here, time for the Popok quarter board. First of all, the chief judge in Miami is Altanaga. Her chief magistrate is Torres. Torres unsealed the indictment, not Bruce Reinhart, who's listed on the complaint, on the indictment as being the magistrate judge. You see up top right, it says Reinhart, but Reinhart sits in West Palm Beach, and he did not unseal. Torres unsealed. The clerk stamp on the top right corner is the clerk, Madam Clerk of the Miami court. So yes, I understand that there was a grand jury that may have been West Palm Beach based that ended up in Miami for COVID reasons, but all signs so far point to Miami. And then finally, Cannon's magistrate, when she sits in Miami, because these judges sort of run the circuit, they run the Southern District from Fort Pierce down to Miami, is not Torres. Her magistrate, when she's in Miami, is Otazio Reyes. And so far, that person's not involved. So I am not yet on board with all the reporting that it's definitely Eileen Cannon, because her name is listed at the top. We're going to see on Tuesday. Yes, there's a random wheel selection in the Southern District. So people are like, how could it be? There's 15 and plus senior judges. How could that possibly be? I'm not sure it is. And then the chief judge is permitted under the local administrative orders of the Southern District to change the trial judge if she so fits, if she sees fit. So Altanaga can change her out by Tuesday or thereafter. And if the Department of Justice doesn't like Cannon, and it really is Cannon on Tuesday, they file either Cannon recuses herself, which she is required to do if she believes there's an appearance of impropriety or bias based on her prior rulings when Donald Trump ran to her courtroom to get to stop the Mar-a-Lago investigation in its tracks, and the 11th Circuit slapping her back, I think she recuses. If she doesn't recuse, they can file a motion, and it ultimately goes up to the 11th Circuit, and the 11th Circuit decides which judge presides over this case. Having said all that, I don't think at the end of the day, Eileen Cannon is going to be the presiding judge for the trial of Donald Trump.
I have my own thoughts that I want to share about Eileen Cannon, which is similar, but slightly different. But I think it will still be very reassuring to all of our viewers out there that I'm ultimately not worried about that assignment. I also want to talk about some of my views within the indictment, but I really want to get your perspective, Karen Friedman Agnifilo. You were the former number 2 at the Manhattan District Attorney's Office. As a former prosecutor, you've prepared indictments at the state level, but you know the process. You've worked with Special Counsel Jack Smith before. From the very outset, when Special Counsel Jack Smith was announced as the special counsel, from the very, very, very first moment you were here on the MeidasTouch Network. I remember that day in November very vividly because a lot of the public had no clue who this guy was. A lot of the large media networks were basically trashing this guy. And you came on and you said, I've worked with special counsel Jack Smith. He is one of the most diligent prosecutors there is. And if he is getting on this case, then this is very, very serious. And Karen, you were right. I want to get your thoughts on this indictment. But first, let's take a quick break.
Your pet's a member of the family. My Lily certainly is. Don't feed them like they're in the doghouse. Give them Nom Nom. Nom Nom delivers fresh dog food with every portion personalized to your dog's needs, so you can bring out their best. Nom Nom's made with real whole food you can see and recognize, without any additives or fillers that contribute to bloating and low energy. That's because Nom Nom uses the latest science and insights to make real good food for your dogs. Their nutrient-packed recipes are crafted by board-certified veterinary nutritionists, made fresh and shipped free to your door. Nom Nom's already delivered over 40 million meals to good dogs like yours, inspiring millions of clean bowls and tail wags. I love my dog so much and feel better giving her better nutrition. And my dog loves the food and other benefits they've seen. Plus, Nom Nom comes with a money-back guarantee. If your dog's tail isn't wagging within 30 days, Nom Nom will refund your first order. No fillers, no nonsense, just Nom Nom. Go right now for 50% off your no-risk 2-week trial at trynom.com/legalaf. Spelled try, NOM.com/legalaf for 50% off. Trynom.com/legalaf. Our next partner is Athletic Greens. My family and I take AG1 by Athletic Greens literally every day. I gave AG1 a try because I wanted better gut health, boosted energy, immune system support, and wanted a supplement that actually tastes great. I take AG1 in the morning before starting my day, and it makes me feel unstoppable and ready to take on anything. I'm doing something good for my body, giving my body the nutrition it craves and covering my nutritional basis. I've tried a ton of different supplements out there, but this is different, and the ingredients are super high quality. Very quickly after using AG1, I noticed that it improved my energy and made me feel great. AG1 makes it easier for you to take the highest quality supplements, period. Just one daily serving covers my day's nutritional basis and supports my long-term gut health with 75 high-quality vitamins, minerals, and whole food sourced ingredients. It's one scoop of powder mixed with water once a day. AG1 is a really seamless and easy daily habit to maintain. I'm asked all the time about the one thing I'd do to take care of my health if I could only pick one. And this is it. AG1 by Athletic Greens. I can't think of another daily routine that pays off as well as AG1, which is why I trust the product so much. If you're looking for a simpler, cost-effective supplement routine, Athletic Greens is giving you a free 1-year supply of vitamin D and 5 free travel packs with your first purchase. Go to athleticgreens.com/legalaf. That's athleticgreens.com/legalaf. Check it out.
Welcome back. We are live here on Legal AF, a historic edition. Donald Trump indicted by a grand jury in the Southern District of Florida. In the first segment, we heard Michael Popok's take on the criminal indictment. And now I want to hear from Karen Friedman Agnifilo, former prosecutor number 2 at the Manhattan District Attorney's Office. You've prepared very, very serious indictments. You've been in the room working with top prosecutors, prepare documents just like this. In fact, you've worked before with special counsel Jack Smith before he was a special counsel, back when he was a prosecutor in the office where you work. So Karen Friedman Agnifilo, your thoughts?
Yeah, so this indictment, I want to just talk about some overall observations. So first of all, this is what's called a speaking indictment or a talking indictment, which is different than a bare bones indictment, which is the other type of indictment, which the more usual kind of indictment. If you recall, Alvin Bragg, when he brought his case against Donald Trump, that was a bare bones indictment that just lists the legal language on or about this date, at this location, the defendant committed the crime of falsifying a business record. And they really, bare bones indictments are what they typically look like. It's just to inform you of the charges. But there is a a tool that prosecutors use sometimes, which is called a speaking indictment or a talking indictment. And that's usually when the charge is either conspiracy, which there are conspiracy charges in this indictment, or if there's a RICO or racketeering charge, which is the type of indictment that we know Fani Willis is considering bringing down in Fulton County, Georgia. So I would expect that there would be a speaking indictment there. And a speaking indictment, all it is a story. You're telling the story of the crime and of the defendants and of what's happening there. And this story that Jack Smith told, you can tell it was written so that anyone can understand it, so that the American public can understand it, a court can understand it, and a defendant can understand it. And it's what's required in a conspiracy indictment. You have to spell out the conspiracy, the agreement, and all of that. But Jack Smith did this in a way so that there was a coherent story that anyone could understand. And that's because this is such a historic indictment. You know, indicting the former president of the United States for violating the laws he swore to uphold, to indict a former president and charge him with obstructing the very agencies that he used to lead, and to indict the former commander-in-chief and charge him with endangering our national security by violating the Espionage Act. I mean, there is no more serious accusation you can make. And so this is such a significant indictment because of what it is doing, that in order to sell this indictment to the American people, Jack Smith had to write this in a way that really justified it. This indictment is more than just these are the charges and what he's charged with. This indictment is a story, and it's a justification for why this indictment is so significant and why Trump's conduct was not at all like the accidental possession of classified or national security information, the way Hillary Clinton's server, or the way Pence found some and Biden found some. Those were accidental possessions, all of them, unintentional. And so what happened when they found them, they discovered them, they gave them back. And I think that's significant, because that's another thing Jack Smith puts in his indictment, is all the efforts that the Department of Justice made to try and get the documents back. Had Donald Trump just said, oh, here, I didn't realize I had them, here they are, and given them back, this indictment would never have occurred. We would never have him be charged. But this isn't just about possession. This is about him thinking that he's above the law and no laws apply to him, and he can do whatever he wants. You know, the one thing that wasn't in the indictment that struck me was motive. Their motive isn't required to prove these cases, and motive is why. Why did someone do it? And we know that Jack Smith was looking into whether Trump had business dealings in the countries where the documents pertained to. And so that was not in here. Now, that doesn't mean that doesn't exist. It just means that Jack Smith wasn't able to prove that, or to get that information in time for the indictment, or maybe it didn't happen at all. So we don't know what the motive is. And I was reading an interview that someone gave who knows Trump well, and said he thought that he kept this stuff as a trophy so he can, he thinks he won the election, and, he still thinks he's president. And so he still thinks he can keep these and use them to show people that he can do whatever he wants. But who knows? Motive wasn't in there, and it doesn't have to be proven. But that was the one thing that I noticed that was missing, that frankly could help with the court of public opinion and persuading people that this is a righteous prosecution. Now, Jack Smith, when he brought this case, there was a lot of chatter that this was going to be in DC. And the reason that's the case was there were aspects of this crime that happened in Washington, D.C., right? He was president in Washington, and these documents existed in Washington, and they had to be taken from Washington to be brought to the various locations, whether it's Florida or the ones in Bedminster that are in the indictment. And we know that there was a grand jury in Washington, not because the Justice Department or anybody leaked it necessarily, but because witnesses were called to testify, and defense attorneys, a lot of the witnesses had defense attorneys or attorneys. And so people talk, and there were reporters stationed outside and would know who went in. And so you could tell that there was activity going on in the Washington grand jury. And then at some point towards the end, and we know we were at the end of the presentation because of the types of witnesses who were being called and the types of cooperators, they move up the chain of command in order of importance. And you could tell where they were based on the types of witnesses that they were getting to. And again, we know that largely because attorneys, we think, leaked this information, not the attorneys at the Justice Department, but attorneys representing the witnesses who went in to testify. And so we knew we were at the end, and that's what all the experts were. You can sort of read the tea leaves and say, okay, based on what's happening now, we can tell we're sort of near the end. And turns out people were right, because it's fairly it's not that complicated to understand when you put all the puzzle pieces together. And so we knew we were at the end, and then all of a sudden everything stopped. And at that point, I had surmised, at least in my mind, I thought, well, I think that's when Jack Smith is talking to Merrick Garland. That's when he's presenting his recommendations and his prosecution memo. And that was just a guess, but that's what I was thinking. And towards the end, when on Wednesday, when we had Legal AF, Popok and I were going back and forth because a lot of people were saying, is this going to be in DC or is this going to be in Florida? Don't forget, at that point, there was information that this case was also being presented in Florida. And one of the things we discussed and that I posited was, I think this whole thing is going to be in Florida and not in Washington for the following reasons. Getting a trial, if you're Jack Smith, getting any trial going before the presidential election is what you want. That is the goal. You want this case to go to trial because we know Donald Trump will never plead guilty. That will never, ever happen. So you want a trial. And the only chance you have at going to trial, because we know Donald Trump's number one trial strategy, it's what he does everywhere, is to try to create delay. And how do you create delay in a federal criminal trial? You make motions, you make legal arguments, and you make arguments that you think you want the judge to rule on. And then if the judge doesn't rule your way, Trump, what does he do? He appeals it. And then what does he go from there? He appeals it to the Supreme Court of the United States. And so what does that do? All of that takes time because Donald Trump does not want a trial. He doesn't want a trial in DC. He doesn't want a trial in Florida. He doesn't want a trial anywhere because a trial will expose all of this evidence in excruciating detail, and it will risk him being a convicted felon, the first in our nation's history. So his goal will be to delay. And the number one problem with bringing this case in Washington is something in the law called venue. And the venue is where do you bring the case? Where does it have to happen? And the law says, the policy says, it has to be where the essential elements of the crime substantially happened. And here, that is Mar-a-Lago, and you can see that now in the indictment. And so in order to take venue off the table as a legal argument, because that really is his number one legal argument that I think would have had the most legs, or at least the most appellate legs. I think he would have ultimately lost, but he could at least make the argument. And so that would have delayed the trial. And so if I'm Jack Smith and Merrick Garland, I think, okay, if I take this down to Florida, it takes venue off the table, and at least I have a chance of a trial. And there's, depending on how many judges were in the mix of who could get this, some people say 15, other people say fewer but I don't really know how Florida works. So I defer to Popok, and he says that it's likely there were 15 judges in the mix. If that's the case, I'm thinking if I'm the prosecutor, there's a 1 in 15 chance it's Eileen Cannon. We know she was a disaster. So I'm going to take my chances because I want to have a trial. And of course, lo and behold, where are we? We're in front of Eileen Cannon. But I think that's why the prosecutor, Jack Smith here, decided to take it down to Florida. And, look, are there going to be some logistics with trying a former president of the United States? Yes. I mean, one of them is assuming Fani Willis also brings her case in July and August, and Jack brings his January 6th case. It's going to be, so we know they're going to have to coordinate at least 3 criminal trials, maybe 4. Which one goes first is anybody's guess. The biggest logistical hurdle, though, I think in this case is the fact that this trial involves evidence of classified documents. So on the one hand, these are our nation's most top secret classified documents. And Donald Trump had over 300 documents that had classified markings that we know of, and over 100 were recovered during the execution of the search warrant. He took over 12,000 government documents total. But so let's say there were there's either 100 or 300 classified documents that were in play that Jack Smith could have used in this indictment. He chose 31 of them. And one question we will all have to ask ourselves is, how did he choose those 31 counts? And because that's a very careful thing that prosecutors do. When you have lots and lots and lots of evidence, I remember when we used to charge crimes that had, you'd recover, thousands of images of child porn, for example. You wouldn't necessarily, each one could be its own count. You wouldn't necessarily charge 1,000 counts. First of all, it bogs down the jury. It's a giant indictment. And so what you do is you carefully select a representative number. And so he would have done that here. And the 31 counts that he would have chosen, he would have carefully selected. And the question is, why did he pick these documents? And, one question I have to ask myself is, perhaps he chose ones that wouldn't endanger our national security if these come out in public, right? For example, did he work with intelligence professionals and only use those that could be used in open court and shown to the jury? But that cuts both ways, because Trump will say, see, they're not national security documents. The jury sees them. You see them. The whole world sees them, right? So kind of by their very nature, you can't necessarily use the most secret ones, because they can't possibly be shown to everybody, because they would endanger our national security. And so or perhaps there's another question. Maybe Jack Smith worked with the intelligence professionals to say, okay, if you can get Donald Trump to agree not to show these to the public and the jury, you can use them until that point. But there is something called the Classified Information Procedures Act, and the judge will have to utilize the procedures there. They'll have a hearing. They call it CIPA. They'll have a CIPA hearing to determine how and in what capacity these documents can be used, while still ensuring that Donald Trump receives a fair trial. And it's complicated, though. So Jack Smith would have chosen these charges very, very carefully when creating this indictment, and that's how these 31 documents got in there. Another couple things, just to put some more other thoughts out there to keep in mind. About this is, Jack Smith will have to, when he tries this case, really keep it simple for the jury. And it really is a simple case. This isn't a complicated case. And that's what any prosecutor does, is you simplify it so that anyone can understand it. And you have to do it in a way that, again, shows this isn't inadvertent. This isn't okay. Donald Trump is going to say, well, I can declassify things with my mind. That defense will easily be debunked. And like I said, venue's off the table, which is good. And, Donald Trump has come out and said also the Presidential Records Act allows him to possess these documents. I guess that's going to be one of his defenses. Well, anyone can read the Presidential Records Act. It's written in plain English, not legalese. And it very clearly says the opposite of what he's saying. And so the jury will not, will be sworn to follow the law. But Jack Smith has to get this case going and has to get this going quickly, because once, if it has to happen before the general election, and hopefully before the nominating process, because otherwise they'll have to press pause and it will not get tried if he is elected president. And of course, if a Republican wins, they could pardon him or stop the prosecution. These charges are very serious. He faces over 400 years in prison if convicted of all of them. But of course, people who have been charged with this type of crime before didn't get anywhere near that. But certainly, I've never seen a case this serious of somebody who held the highest office in the country and swore to uphold the laws. So who knows what he will get. And there's just one other thing I want to talk about, which is something, I watched Ben's hot take on Eileen Cannon and how he's not worried if she is ultimately the judge. So let's talk a little bit about what is going to happen if she's ultimately the judge and what are some of the mischief rulings she can do in this case. So number one, as Ben and Michael Popok both said, I can't believe I called you Michael. I always just call you Popok. But as Popok and Ben just said, it's not clear that she's going to ultimately end up with the case. But there's a couple of issues with this if she does end up with the case. So number one, she could be, for the reasons Ben has talked about in his hot takes, and I'm sure we'll talk about more here in detail, there could be an issue that she has to be recused from the case because she has already shown that she's not competent to have the case. And I think that she has made a couple of rulings in the prior, it's a civil case that she had, right? There was the execution of the search warrant, and then she inserted herself in a civil proceeding and appointed a special master and was reversed. So I think there's a chance that you can bring like Ben has said, you can bring an action to recuse her from this case because she has shown that she's biased and not competent to hear this case. So I think there's a good chance of that. But also, let's say she's not recused from this case and she does take this case, there is some mischief she can do. And there are rulings first of all, she can delay it, so that it doesn't happen before the election, which would be potentially fatal to this prosecution. She could rule, for example, that if you recall, Beryl Howell ruled all the attorney-client conversations between Evan Corcoran and Trump and others and Trump, they fall under the crime fraud exception, which is why the DOJ got all of that evidence and that testimony. Well, that ruling doesn't follow. It's not the law of the case because that case, this is a trial judge who can make trial rulings. So she can reverse that if she wanted. Now, I don't think she will, but she can. She can create mischief. The other possibility is she wants to redeem herself if she keeps this case and suddenly becomes a real judge and wants to, because she was raked through the coals by the 11th Circuit, which is the circuit that rules her and reversed her and essentially called for lawless. So maybe she wants to redeem herself. Who knows? So there's lots of possibilities with Eileen Cannon. But for anyone who says, oh, a judge is just a referee and just calls balls and strikes, and this is Smith's prosecution, there isn't much she can do. They're 100% wrong. A trial judge can make or break a case. They can suppress evidence. They can rule evidence inadmissible, important evidence, or rule other evidence admissible that shouldn't be. And a lot of that is not appealable mid-trial. You have to wait until appeal. And if there's an acquittal, there's no appeal for Jack Smith. So let's hope and pray that it's not Eileen Cannon. I don't trust her. I think she's a terrible judge. And I think she can harm this case significantly and even possibly make it so it not go to trial. So whatever anyone can do to figure out how to get her off, I think it'll be the best thing for justice. I think at this point, that's about all the comments I have to say. I'm going to bring in my co-hosts, but I think those are my overall observations and comments about about this case, about this indictment, and about this prosecution.
Well, I think the analysis, both from you, Michael Popok, from you, Karen Friedman, Agnifilo, is incredible. One of the cases that I think the prosecutors are going to lean on in trying to get Aileen Cannon recused is a 2006 case called U.S. versus Martin. And I want to talk about it because it's binding 11th Circuit precedent on the issue of recusal or reassignment of a judge, where a judge has made multiple rulings in the past that the 11th Circuit Court of Appeals has overruled. So it seems to be directly on point. But then I also want to touch upon CIPA, which you mentioned, because I think we're going to be hearing a lot about CIPA. This is a case involving the theft of classified information, top secret information. As you mentioned, Karen, it stands for the Classified Information Procedures Act. We're going to be hearing a lot about that. And I think in particular, Section 6A and Section 6C, which basically deal with the hearing regarding classified information and whether or not stipulated facts could be substituted in place of actually showing a jury classified information while preserving the due process rights of criminal defendants in the case. There is a whole procedure for how the different parties petition to have a document be determined as classified information. And again, this is where if Judge Aileen Cannon is conducting the initial review, there could be some mischief done there. But CIPA also has a process where petitions are made to the circuit court, given the unique nature of classified information. But in theory, what the substitution does so that jury and the public are not actually exposed to the highly classified information, they get a stipulated set of facts, or there's some other way to convey the exact same information about what the documents are. So, for example, when we go to the 31 counts on page 28 of the indictment, and they talk about these records at page 28, 29, they go, documents relating to military records of an adversary, military records of an ally, nuclear records. That description would be similar to what a substituted stipulated set of facts can be. So everybody will start introducing that term CIPA, the Classified Informations Procedures Act. And I want to give my own view about Aileen Cannon, and I want to go over a little bit of additional facts that are in that speaking indictment that was just unsealed. That and more after this quick break.
Let's take a quick break to talk about our next partner, ZBiotics. Now, if you're like me, you've probably skipped a workout because of drinks the night before. It happens. But if you're committed to your healthy routine, you need ZBiotics. ZBiotics Pre-Alcohol Probiotic is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. ZBiotics produces an enzyme to break this byproduct down. It's designed to work like your liver, but in your gut where you need it most. Just remember to drink ZBiotics before drinking alcohol, drink responsibly, and get a good night's sleep to feel your best tomorrow. Now, I can't lie, after we hit 1 million subscribers, I may have partied a little bit too much that night. But luckily, I knew I had ZBiotics. Now, as instructed, I drank a bottle of ZBiotics before any alcohol, and I was amazed at just how good I felt the next day. Give ZBiotics a try for yourself. Go to zbiotics.com/legalaf to get 15% off your first order when you use LegalAF at checkout. ZBiotics is backed with a 100% money-back guarantee. So if you're unsatisfied for any reason, they'll refund your money, no questions asked. So remember, head to zbiotics.com/legalaf and use the code LegalAF at checkout for 15% off. Thank you, ZBiotics, for sponsoring this episode.
This is Michael Popok, Legal AF. Cold turkey may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo from your wacky neighbor or some sketchy message board. We're talking about our sponsor, Fume. And they look at the problem in a different way. Not everything in a bad habit is wrong. So instead of a drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, fume is completely natural. Instead of vapor, fume uses flavored air. And instead of harmful chemicals, fume uses all natural, delicious flavors. You get it. Instead of bad, fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which helps with de-stressing and managing anxiety while breaking your habit. The first time I used fume, I was shocked at how flavorful and fresh it tasted. It's easy to hold and perfectly balanced. Quite honestly, extremely fun to fidget with. The real wood material and sleek design definitely classes it up, and I feel pretty darn cool holding it. Stopping is something we all put off because it's hard, but switching to fume is easy, enjoyable, and even fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com and use code LEGALAF to save 10% off when you get the Journey Pack today. That's tryfum.com. Use code LEGALAF to save 10% off the Journey Pack today.
Welcome back to Legal AF. We are live. I want to thank Karen Friedman Agnifilo for her analysis. Unfortunately, Karen had to go, so you just got me and Popok here. But I really always love to hear from Karen Friedman Agnifilo. And by the way, remember, she was the first person. I remember that day so vividly last November when everyone was saying, who's this Jack Smith guy? Merrick Garland is just trying to, put this on someone else so that they could, not actually charge Donald Trump. And Karen Friedman Agnifilo was the first voice that pushed back on that and pushed back on it powerfully. And then the large media networks started catching up to it and saying, hey, this Karen Friedman Agnifilo is right. And I was like, yeah, she ran the Manhattan District Attorney's Office. She was like the acting Manhattan District Attorney. She was the number 2. Of course, she's right. Karen Friedman Agnifilo is absolutely the best. Where we last left off before we took that brief break, I was talking about the case law in the 11th Circuit Court of Appeals. That's the Court of Appeals, the circuit court that supervises or oversees Florida federal courts, among other federal courts like those in Georgia. And I talked about the binding precedent on reassignment and recusal here, and it is very much in favor of Aileen Cannon recusing herself. Whether she recuses herself on her own, she's previously has demonstrated a propensity for not doing the right thing. Will special counsel Jack Smith on his own seek the recusal, or will the DOJ seek a recusal motion, or will the 11th Circuit kind of sua sponte, or a presiding judge basically say, no, Aileen Cannon, you are not on this case, and demand a reassignment and make the reassignment happen. But here's what happened in this U.S. versus Martin case. On Section 4 reassignment, the 11th Circuit Court of Appeals reviews the record in that case where a district court judge continued to make rulings in a sentencing matter that the 11th Circuit Court of Appeals continued to overrule. Not once, but twice, where the 11th Circuit Court of Appeals said, you're not following the guidelines. You're not following, for whatever reason, with respect to this specific defendant, who, by the way, was not the defendant who appointed you to the position, but you keep making the incorrect ruling, and we're giving you the guidelines. So finally, in this section, the 11th Circuit said our settled practice is to direct a specific judge to reassign a case, whereas here the district court on multiple occasions has been overruled and reprimanded by the 11th Circuit Court of Appeals. And let's not forget, Judge Aileen Cannon was not just overruled once by the 11th Circuit Court of Appeals. There are 2 orders by the 11th Circuit Court of Appeals stating that Aileen Cannon never had jurisdiction in the first place, that she intentionally interfered with the Department of Justice's criminal investigation. And by the way, not in just any old matter, in this matter, in the search warrant executed at Mar-a-Lago by the Department of Justice, at Mar-a-Lago back in August 8th of 2022. That's where she improperly, illegally, unlawfully interfered with two 11th Circuit Court of Appeal orders saying that she impermissibly and improperly interfered and didn't follow 11th Circuit precedent. I think that the 11th Circuit will not want her to be a stain on that circuit court. And as a result, I think they will ultimately, I think that she will be recused. However, I do think while there is a ton of mischief, as Karen mentioned, that a district court judge could bring, I do think that, and again, this is why I'm very, very confident here. This indictment is so powerful and so bulletproof. You even had people like Jonathan Turley, who is the right-wing kind of legal spokesperson for all things kind of MAGA legal conspiracy theories. It's so unfortunate that that's what happened to Jonathan Turley's career. He's a con law professor at the George Washington University, where I went to undergrad, not where I went to law school. I went to the competing school at Georgetown. But I think that when even Jonathan Turley looks at this and goes, wow, this is very, very damaging. And he did it on Fox. That speaks volumes. So I want to go into, oh, and by the way, have you seen this New York Post cover as well? Chamber of Secrets. And it's showing the photographs from the indictment. And these are the boxes that are in the bathroom right by the shower in Mar-a-Lago. And by the way, you have a lot of right-wing, disinformation sources all basically saying, looks like the FBI did it. Again, is it the FBI's taking these photographs and making it messy? No. Though, if you just read the lawsuit, like we have the photo up now for those who are listening in audio, and obviously for all of our YouTube watchers, you can actually see this. But this is Walt Nauta texting another Donald Trump employee. So Trump employee who's been indicted, Nauta, texting Trump employee 2 saying, I opened the door and found this. It's Trump's employee's photo. This isn't a DOJ photo. And then for all of the people who say, I don't see any classified information, just read the indictment. Like, that's the thing with these right-wing people. They lie and they don't show their viewers the actual text. Because if you read this, the next sentence says, Nauta also attached 2 photographs he took of the spill. Trump employee 2 replied, oh no. And I'm sorry, POTUS had my phone. One of the photographs Nauta texted to Trump employee 2 is depicted below with the visible classified information redacted. Trump's unlawful retention of this document is charged in count 8 of this indictment. So it is redacted. That is why you can't see it in the photo. But if you look on the kind of the right of the box where the documents are flowing out of, you can see the cover page with the classified border, and it is redacted. They're not referring to the newspapers. The issue is that the classified information is being hidden within the newspaper clippings, and the classified information page is redacted. And if you just read the document, it says that. That's why it's important that we read this document. Let's just read some portions of this document, okay? Let's go to paragraph 3 of this, which I think is one of the most powerful of the paragraphs, which says, the classified documents Trump stored in his boxes included information regarding defense and weapons capabilities of both the United States and foreign countries, United States nuclear programs, potential vulnerabilities of the United States and its allies to military attack, and plans for possible retaliation in response to a foreign attack. The unauthorized disclosure of these classified documents could put at risk the national security of the United States, foreign relations, the safety of the United States military and human sources, and the continued viability of sensitive intelligence collection methods. And then if you go to page 28 and 29 of this indictment on the 31 counts for the willful retention of the records, page 28 and 29, like, they list what is in paragraph 3. Like, that's why you got to read these things and you got to follow them. So here's an example. count number 3 for willful retention of national information, national defense information. And it gives the classification: top secret, sensitive information, no foreign, meaning it can't even be shown to any foreign governments. It's so top secret, even among their intelligence communities. Undated document concerning military capabilities of a foreign country and the United States, with handwritten annotations in black marker. Okay, that's Donald Trump in black marker doing it. As you go to count 5, document dated June 2020 concerning the nuclear capabilities of a foreign country. Count 6, document dated June 4th, 2020 concerning White House intelligence briefings relating to various foreign countries. So on and so forth with all of the counts. They're all like that. Going to paragraph 6A and 6B of the complaint. In July 2021, at Trump National Golf Club in Bedminster, New Jersey, during an audio recorded meeting with the writer, a publisher, and 2 members of his staff, none of whom possessed a security clearance, Trump showed and described a plan of attack that Trump said was prepared for him by the Department of Defense and a senior military official. Trump told the individuals that the plan was highly confidential and secret. Trump also said, as president, I could have declassified it, and now I can't, but this is still a secret. And then 6B, in August or September 2021, at the Bedminster Club, Trump showed a representative of his political action committee who did not possess a security clearance a classified map related to a military operation and told the representative that he should not be showing it to the representative and that the representative should not get too close. And then if we then go kind of deeper into the complaint, where we actually see from 6A and from 6B, let's turn to page 22 and 23 for a second. These are messages, text messages as well, from Walt Nauta to members of Donald Trump's family. And on page 22 and on page 23, as Popok described earlier, these are communications with, it seems to be Melania, where she's saying Donald Trump wants very specific documents pulled. Donald Trump wants to, bring certain ones with him, but not the full boxes. And so again, you have very detailed factual allegations here. Here's the actual message. On May 30th, 2022 at 12:33 p.m., a Trump family member texted Nauta, "Good afternoon, Walt. Happy Memorial Day. I saw you put boxes to POTUS room, just FYI, and I will tell him as well. Not sure how many he wants to take on Friday on the plane. We will not have room for them. Plane will be full with luggage. Thank you." And so again, they're talking about Donald Trump taking very specific documents. And this was right before June 3rd of 2022, where the Department of Justice showed up at Mar-a-Lago to obtain all of the classified records in response to the subpoena. Finally, I just want to show you from that allegation that we had just mentioned, 6A and 6B. Turn to page 15 and 16 for a second. And when you look at 15, it has the entire audio recording of Donald Trump bragging about this classified information. I mean, just look at this dangerous idiocracy here. Trump goes, well, with talking about a senior military official who we believe to be General Milley, chairman of the Joint Chiefs of Staff. He goes, well, with this senior military official, let me see that. I'll show you an example. He said that I wanted to attack country A, and we believe country A to be Iran. Isn't it amazing? I have a big pile of papers. This thing just came up. Look, this was him. They presented me this. This is off the record, but they presented me with this. This was him. This was the Defense Department and him. And then some random writer who's like ghostwriting a book for Mark Meadows, who Donald Trump is showing this classified information about a plan of attack on Iran, goes, wow. And then Donald Trump goes, we looked at some. This was him. This wasn't done by me. This was him. All sorts of stuff, pages long. Look, Donald Trump is showing him here the classified information. And a staffer goes, and Trump goes, wait a minute, let's see here. And then the staffer starts laughing. And Trump goes, I just found this. Isn't that amazing? This totally wins my case, And a staffer who has to be like a yes person with him goes, And Trump goes, except it is highly confidential. And then the staffer goes, yeah, and starts laughing. And Trump goes, secret. This is secret information. Look at this. You attack and by the way, isn't this incredible? And then the staffer goes, yeah. And then Trump goes, I was just thinking because we were talking about it. And he said he wanted to attack Iran. And what, staffer, you did, Trump. This was done by the military and given to me. I think we can probably write, staffer. I don't know. We'll have to see. Yeah, we'll have to try to. Then Trump goes, declassify it? And staffer goes, figure it out. Yeah. Then Trump goes, see, as president, I could have declassified it. And the staffer goes, yeah, Trump, now I can't, but this is still a secret. The staffer, yeah, now we have a problem. Trump, isn't that interesting? This is life or death stuff, folks. This is life or death stuff. You know how many of our assets, people in our military, people who defend our country could have been and may have been killed because of this? And they're laughing at it. And Trump's showing it to just random people, don't have security clearances. And if he's just showing it to random people and saying that kind of lunatic stuff, imagine what he's doing on a daily basis when it wasn't recorded like that. Horrific, horrific, horrific. But I just wanted to drill down on those portions. Finally, I just want to mention that Donald Trump's lawyers have left. Jim Trusty, that is, and John Rowley, who were the leaders of his defense in connection with the investigation prior to the indictment being issued and then unsealed. Donald Trump put out a message that seemed to imply that he fired them. And then I wrote on my Twitter account, I go, how soon after do we find out that they resigned? Like literally within 3 minutes later, they stated that they tendered their resignation. And they claim the reason they are resigning is because special counsel Jack Smith venued this. He filed the case in the Southern District of Florida. And that's why, and they don't practice there is what they said in their resignation, which absolutely makes no sense to me because the lawyer who Donald Trump now has leading the legal team, Todd Blanche, is a New York Wall Street lawyer, not a Miami lawyer, not a Florida lawyer. And Jim Trusty previously was handling Donald Trump cases in Florida, in federal court in Florida, as well as before the 11th Circuit Court of Appeals. So I don't buy that at all. And then Popok, finally, what do we look forward to next week? We have the arraignment. Can you just maybe briefly explain what an arraignment is? There's not going to be cameras in the federal court building. There aren't cameras in federal courthouses. I think they should be. Yeah. So what happens on Tuesday?
All right, well, let me start there, and then I'll back up a couple of things. Karen said a couple of things that you said that I thought were interesting that I can amplify. We're going to have an arraignment on Tuesday. We're going to know who the initial judge is going to be. The initial part of the arraignment is usually done by a magistrate judge, even though it says Reinhardt, who was the magistrate judge that issued the search warrant. I don't think it's going to be Reinhardt. The speculation and people that practice down there think it's going to be Chief Magistrate Judge Edwin Torres, who unsealed the indictment. And there'll be kind of what we call, first day orders. Let's talk about trial in this case, gentlemen. Let's talk, ladies and gentlemen, let's talk about when it can happen. Motion practice related to that. Let's talk about pretrial conditions of release from arrest, because he is going to be, Donald Trump will be arrested second time in 2 months, indicted second time in 2 months. He has to go through the same process, DNA, fingerprinting, pictures and all that. It's less, it's more stringent than even what happened to him in the Manhattan side. He'll do that with the federal officers, come back through the doors with his attorneys, whoever they may be, in addition to Todd Blanche. Where is Chris Kise, by the way? Chris Kise is a Florida lawyer that he gave over $5 million to through his political action committee, because supposedly he was a Florida lawyer that knew what he was doing. He's nowhere to be found. Lindsay Halligan is a insurance defense lawyer, a very young one at that, in Fort Lauderdale. Even though she's been brought to various meetings, there's no way she's going to remain in the case. But we'll see who the lawyers are going to be on Tuesday, who the magistrate's going to be on Tuesday, ultimately who the judge, if this judge issue is not resolved by her recusing between now and Tuesday, And we've been involved with cases, Ben, you and I have been involved with cases where we thought we had one judge federally, and then they recused or disqualified themselves for various reasons. We had another judge or two other judges. We've been involved with the cases where a third judge got assigned within a week. So I think that could all get sorted out even before.
You can't bury the lead there of what the case was. It was when we sued Marjorie Taylor Greene, and she ended up settling with us.
That's true.
I mean, let's talk about that case. So,
I forgot that.
Popok was the lawyer for MeidasTouch, sued Marjorie Taylor Greene for blocking us on Twitter. Marjorie Taylor Greene settled with us, paid us $10,000, and then we took the $10,000 and then we donated it to two groups that were for support of responsible gun ownership.
But we had three.
As a result,
Right,
Marjorie Taylor Greene, based on the signed settlement agreement, is not allowed to block anybody ever again on her Twitter account. So anyway, back to you.
Yeah. But we had three judges within 5 days, so I think it gets sorted out on Tuesday. When I hear the reporting for those that are in the room, I won't be able to get down to Miami for this one. I'll know Edwin Torres, magistrate, because Edwin Torres is not Eileen Cannon's magistrate. When she goes to Miami, very rarely. She is the least senior, as we've talked about in the past, of the 15 judges in seniority. She is still the least senior because there hasn't been a new appointment by Biden in the Southern District, because there hasn't been an opening and there hasn't been an expansion of those seats. So that's going to tell us a lot. She either gets out, Chief Judge Altanaga takes her out under the discretion that the Chief Judge has under the local rules and administrative orders, or ultimately on motion, by the Department of Justice on the case law that you cited, Ben, the 11th Circuit ultimately takes her out. So I don't think we have to worry about her. But if Jack Smith comes into the room and Jay Bratt, who signed the certificate of trial lawyer, which we have here in the back, in which he picked West Palm Beach, by the way, as the venue, as the court division within the Southern District, said it's about a 21-day trial. This is part of the speedy trial that Jack Smith said in his press conference when he said, we believe that people are innocent until they're proven guilty. So we got to get to trial quickly in order to do that. They are going to go like full steam ahead, as Karen outlined, to get this thing to trial, whether it's cited in Miami or back in West Palm Beach, whoever it's going to be. And if it's not Eileen Cannon and it is in West Palm Beach, it probably rotates to Judge Middlebrooks. Wouldn't that be a special delight for everybody? Judge Middlebrooks, who already sanctioned Donald Trump once for civil filings that had no merit. So we'll see how that plays out on Tuesday. Will he be detained pre-trial, pending the trial? No, not based on the crimes, even as egregious as they are. Will they pick up his passport? It'll be discussed. Will they limit his travel? It'll be discussed. He has to assure everybody that he'll appear back in these courtrooms for the various proceedings, almost all of them that are done live and not by video. So he'll have to appear for those, and they'll potentially set an initial trial date, or come back for a hearing in 30 days for an initial trial date and set that as well. Government wants to do what they say is a 4-week trial, maybe 6 weeks or 8 weeks, but that's it. And they want to do it in, early 2024. I'm sure of course, Donald Trump's other concern is he's got another criminal trial in May of 2024 in New York. March of 2024. So you got all that going on. In terms of the counts that we talked about, I think it's important, as Jay Bratt signed in his own filing, the penalty sheet. God, I never thought I'd see the day where there'd be a penalty sheet assigned to Donald Trump in federal court. Most of the Espionage Act claims are 10 years, but for each count, with supervised release of 3 years and $250,000 in fines. The obstruction of justice conspiracy is 20 years. Withholding a document or record, 20 years. Concealing a document, 20 years. Concealing a document in a federal investigation, 20 years. Scheme to conceal, that's 5 years. So there's a false statement is 5 years. You add it all up, it's like 400 years in prison if they were done not concurrently. But that's the government's position. In terms of the things, you hit all the highlights, but I just wanted to give a couple that were interesting to me. The DOJ's indictment through the grand jury says emphatically that Donald Trump misled the Secret Service as well, that the Secret Service didn't even know he had highly classified top secret documents. That's one. I was shocked by the level of involvement, personal involvement by Donald Trump in the search for documents, in withholding documents for the National Archive, the presidential records, him self-selecting the 15 boxes in the dress rehearsal that he would try to serve up to the National Archive, that he personally, Donald Trump, reviewed those, that he personally gave the commands and had boxes, 80 of them removed from the storage room and only 50 of them returned, and Lord knows what happened within those boxes. Those were based on Donald Trump's personal review of those documents. The quality of the evidence that they have developed to be able to say that emphatically in the complaint was mind-boggling. I always suspected that he would be involved, but that there would be levels of buffers between him and others. No, he was doing bring me 2 more boxes, texting himself to Walt Nauta, give me another box. I need a new lid for one of these boxes, and then, get him to Bedminster. So they were this shell game of moving them all out of the White House, and then him, Donald Trump, picking which ones would go back to the National Archive, holding back 70 or 80 other boxes, including classified, but even screwing that up because they had classified documents in the initial return to the National Archive, which led to the DOJ referral, which led to the summons and then to the search warrant. And then just the brazenness in which he thought he'd be protected by attorney-client privilege to tell Evan Corcoran, hey, when you get that envelope and back to your hotel room, if kind of poof, some of them disappeared, that wouldn't be bad. Like the Hillary Clinton IT guy, do that. I mean, the fact that he would even say that out loud, and thank God we've got judges, Ben, sitting in the District of Columbia, chief judges like Beryl Howell and now Jeb Boasberg, who listened to this evidence early on. We didn't have privy to it, and were able to decide that there was a crime or fraud perpetrated likely by the President of the United States in the way he dealt with his attorney. And thank God, Evan Corcoran, he didn't know it at the time, but that his 50 pages of handwritten, detailed notes about his interaction with Donald Trump and his audio musings, thank God they got turned over to the government. And we said when that first happened, I think you remember the Legal AF, Ben, we were like, wow, notes? Attorney notes? I mean, I'm thinking, well, maybe some random scribblings. 50 pages of detail. This guy was like methodical. The other thing that was fascinating about it and really damning for Donald Trump, for me, in the indictment, and it may answer the question that Karen posed before she left, which is, what was the motive? The motive apparently looks to me like, these were my papers. These are mine. He said to his staff, these are mine, 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 mine. He told his lawyers, Corcoran, so what do you got to do for the subpoena response? Well, I got to look through all of your documents, Mr. President. I don't really want, this is quoted in the indictment, I don't really want you looking in my boxes. I don't want you really looking in my papers. They're mine. So this mine, this possessiveness, this narcissism is how he treated these documents. His own staff joked, and this is in the indictment, referencing the movie A Beautiful Mind about John Nash, the troubled economist. And if people remember the scene in the movie where he's literally lost his mind and is living in a shack behind his house, where he writes on the windows of his house all sorts of crazy formulas, and the house is just packed with documents piling out of things. So they joked that they called it the Beautiful Mind paper boxes, which were just stuff that this guy in larceny, Trump, threw into the boxes, spilling out with classified and top secret. He wanted the Beautiful Mind boxes for his own. That, whether it was a memento, he thought he was going back to the presidency, he wanted to show it off transactionally or use it, whatever. That's the motive. Because otherwise, right, it doesn't make any sense. Like, why does he just give it back? What? He doesn't give it back because he believes that he owns it and not the American people, and sees nothing wrong. And then finally, Ben, I love that they hoisted him on his own petard, Donald Trump, and Jack Smith, the way they wrote this really elegant, efficient word economy. Every word, every sentence advanced the cause. There was no wasted sentences in this indictment. Very, very elegantly written, but simply written in the narrative. I love that they said to him, hey, you yourself in 2016 and 2017, 2018 made a lot of statements about classified documents. You made a lot of statements about how you would protect the national interest and how people who leave office that continue to have access to classified documents would only, who have a political partisan role in their future life should never have access to these classified documents. That is a moment of inadvertent self-admission by Donald Trump, because he just described himself leaving office, having no reason to hold on to these things. He's a partisan running for office, holding on to top secret documents. Really, really well done. I learned about 40 new things that we couldn't even have speculated about the deep involvement, personal involvement up to his elbows, Donald Trump himself, in the document scandal.
Yeah, and I definitely think the motive also, and you touched on it, was transactional, was money. The examples that we have in this indictment were Donald Trump just showing it around like trophies and bragging about it as a tool of trying to have continued relevance based on being a malignant narcissist. Hey, isn't this cool? I really am the winner here. Like, not only is it so dangerous, like just a complete and utter idiocracy, which is what we always call out here on the MeidasTouch network. But Donald Trump has said before, he's like, Nixon traded his documents for $18 million. So clearly in the back of his mind, he had views as a prior criminal who held the office. And Donald Trump makes up these stories in his head. And Donald Trump, again, what we have in the indictment are two examples where it was recorded of him bragging about these documents and showing it. Those are exemplars. Those are not the totality of instances when Donald Trump did this. It's on tape. So how could a jury ever go, well, that didn't happen? Here it is. Play tape. But if he did it in those two instances, I think the point of those is think about every time he did that before as well, and would continue to do it if he's not stopped. You mentioned the ruling by the federal judges in Washington, D.C., presiding over the grand jury, finding that the crime fraud exception applied, that Donald Trump was using his lawyers for the commission of ongoing criminal conduct such that they couldn't assert the attorney-client privilege to shield documents and try to preserve their confidentiality from being turned over to the Department of Justice. And a lot of those rulings were by federal Judge Beryl Howell, who used to be the presiding judge in Washington, D.C., over the criminal grand juries there. And now it's someone by the name of James Boasberg, who goes by Jeb Boasberg, who presides over the grand juries as the presiding judge in Washington, D.C. District Court. And he's made a number of very important and favorable rulings in the other case that's still being investigated by special counsel Jack Smith for Donald Trump's election interference, for Donald Trump's attempts to overthrow our democracy. And we've got some insight into the type of powerful evidence that has already been presented before first Judge Beryl Howell and now Judge Boasberg. And that case, that investigation is proceeding. We expect the same way we were predicting the indictments on the case involving Trump's theft of government records and obstruction of justice to land pretty much precisely. We were spot on, I think, if you go back and rewind the episodes of when we said that one was coming. I think we said May or June, potentially a little bit later, but definitely summer, probably early summer. We all think that the other indictment is going to happen sometime in September, October, maybe late August, but we believe there's definitely another indictment coming from special counsel Jack Smith. And again, that's from everything for the conduct on January 6th, the day of the insurrection itself, leading up to it, wire fraud, campaign finance violations, threatening state and local election officials, and the fake elector scheme, all of that criminal conduct by Donald Trump. But an order that was just unsealed by Judge Boasberg, and it's very rare that we get insight into what's going on in the grand jury process. So what Judge Boasberg did, because Pence gave a media interview and there's just been a lot publicly discussed about former Vice President Pence testifying before the grand jury, Trump's talked about it. Pence has talked about it. Trump's lawyers have talked about it. And so the judge basically got a motion from media interveners who said they want to get their hands on the transcripts and everything relating to former Vice President Pence's testimony before the grand jury. And the judge is like, look, grand jury proceedings are confidential. They always are in secret. However, I can release portions of the order compelling former Vice President Pence to testify, where the court overruled the assertion by former Vice President Pence that the speech and debate clause privilege, a privilege for senators and members of the House of Representatives not to have to testify in other actions, and immunity from various types of cases. When the court overruled that largely, the court found that the speech and debate clause in a limited sense applied to former Vice President Pence in his ceremonial role as the president of the Senate. So when he was in that capacity and leading up in his preparation for his role as having the ceremonial duty of counting the electoral votes, the court said, for that limited purpose, I'll acknowledge the speech and debate clause applies, but for everything else, and everything else is what special counsel Jack Smith really cared about. All of Pence's observations of Donald Trump committing crimes, all of Donald Trump threatening Pence, all of that is fair game, and former Vice President Pence can testify on that. I just want to show you just a few pages here where the judge seems to, certainly hint at the evidence before them that, yes, it's fair game because Donald Trump was committing crimes. So if you go to page 16 of Boasberg's order that was just unsealed, again, this order comes from March of this year, but it's now first being unsealed on last Friday. And the court basically says, having set out the ground rules, the court may now get down to business. It assesses these specific topics, and those are redacted. In order to provide guidance to the parties going forward, it notes several areas within those categories that the privilege does or does not cover. The bottom line is that the conversations exhorting Pence to reject electors on January 6th are not protected. They fall under Brewster's rule. The Brewster is a case involving a senator who was taking bribes. Okay, so that's what Brewster refers to. They fall under Brewster's rule that communications urging a legislator to act unlawfully or ultra vires are not preparatory, or at most only incidentally so, to a legislative function. There is no dispute in this case that Pence lacked the authority to reject electoral votes. Then there's a redaction. Indeed, as Pence described in his book, he never believed that the vice president's role on January 6th was anything more than ceremonial. So here, the basis of the court's ruling is that where someone is being instructed to act unlawfully, those are not legislative in nature. So they're analogizing Trump to this other case where someone acted unlawfully. And then finally, if you go to page 19, it goes and explains this privilege that Pence is citing, and how the court is construing it applies in a way that is broad enough to ensure the historic independence of the legislative branch, but narrow enough to guard against the excess of those who would corrupt the process by corrupting its members. Okay? So in compelling former Vice President Pence to testify, what the court is saying there is that Donald Trump was corrupting the process by corrupting its members if Pence was trying to claim an immunity like being the president of the Senate. It's subtle, but very, very powerful, and tells you that that case is moving towards very, very serious charges as well. And I'll pass it to you, Popok, but if we saw 38 charges that were brought in this case in the Southern District of Florida for the willful retention of national defense information and obstruction of justice, I've always said I thought you're going to see hundreds of counts in connection with the January 6th case that's being investigated. I think you will see hundreds, 200, 300, definitely I think close to 200 counts in that indictment, Popok.
I think you just made a hot take for all the Pence things there. I don't think that's it. You're done. Salty, cut it. You're ready to go. But let me see what I can hit. I want to make a statement, as you and I have been talking about things for over 2 years, to the audience members globally and locally. What we are describing in sometimes excruciating but hopefully entertaining detail is a justice system that works. I know that we talk about, how many times is he going to get away with it, Donald Trump? How many times is he going to be, yes, there'll be a suit, but will he be forced by a jury to pay anything? The answer to that has been yes. Look at all the suits that he files, 90 of them attacking the election. Maybe one of them will be successful. They weren't. Maybe his appeals even to the Supreme Court that he has packed with MAGA right-wing 6-3 majority will give him wind at his sail. It doesn't. The federal judges on the circuit court, some of them are appointed by him. Maybe they'll come to his rescue in response to something. They haven't, they won't, and they can't. And so we talk about Eileen Cannon at length for good reason, and she was a poor example of the federal judiciary at a moment that was important to our nation's history. But for everything else that you and I have talked about in the last 2 years involving Donald Trump, his henchmen, and his cronies, the Justice Department, especially the federal one, but even state, works. So, and it's something to be proud of. And I'm proud today. I know there's a whole bunch of lawyers and lackeys and hanger-oners and bootlickers for Donald Trump, like Alina Habba, who got on television, and they're still doing it. Carrie Lake made a comment during a press rally that there's a Second Amendment solution to Merrick Garland and Jack Smith's indictment of Donald Trump. I mean, that sounds like the Secret Service should start opening an investigation into Carrie Lake's threats against the Department of Justice, and they should. So the right-wing MAGA are coming out with, sad day in America, sad day for justice. I'm ashamed to be a lawyer. It's the opposite. This is what the founding fathers wanted. It is a major protection guardrail, firewall for our democracy, the conscience of our democracy. And every time you and I tell this of what's happening, whether it's Jeb Boasberg, Beryl Howell, the judges of the DC Circuit Court, even the judges of the Supreme Court in rejecting Donald Trump's entreaties to interfere in justice, we are watching this in real time. Some people get frustrated and get fatigued and like, I'm tired of hearing about it. Tell me when he's in jail. But this is the process, the journey that we're on together. This journey that we're on together is our justice system. It's like the old John Lennon line. Life is what happens when you're making plans. This is the justice system in all of its glory and warts and all. But at the end of the day, when adults are in the room wearing the black robes and you have lawyers like some of the finest at the Department of Justice handling the case with Jack Smith, good things come out of it. And thank God that they do. This is why the rest of the world should be proud of our system of justice, because we just indicted twice in 2 months a former president of the United States for the first time in American history. And although it may not mean something to those that are continuing to run for office and to grift, it means something to everyone else that cares about democracy and justice.
And we are so proud that all of the legal AFers, everybody watching this who has been with us from day one, or if you're just joining us now, welcome. But none of this is possible, without you. This community, this pro-democracy community that speaks the truth. Michael Popok, Karen Friedman, Agnifilo, myself, my brothers, all of the other hosts on the MeidasTouch network. We just got sick and tired of large media networks gaslighting us and not giving us the facts and not spending the time to explain the justice system and not spending the time to go through what's actually stated in the complaint and showing the photos and explaining the complexity and talking about issues that may be difficult or complex, but we ultimately know that that's why you're here. You want to learn about that. We wanted the media to be like that. And so when we didn't see the media doing that, we just said, we're going to create it ourselves. So we did it. We built the MeidasTouch network. We built out Legal AF and all of the other shows on this network. But most importantly, what you built is what's been most impressive to me, and that's real community a real unapologetically pro-democracy community. And I know after you watch these shows or after you listen to these shows on the MeidasTouch network like Legal AF, you share this knowledge with your family, friends, coworkers, colleagues. You spread the word. You let people know these facts so that we can rebut all of the disinformation out there. And we're so grateful for you. And so from the bottom of all of our hearts here at Legal AF and the MeidasTouch Network, we say thank you. And it's an honor to be working by your side. Historic episode today on Legal AF. We'll see you for the midweek edition with Michael Popok and Karen Friedman Agnifilo, which is always live on Wednesday evenings. I'm sure there's going to be a lot of information to report. I'm sure there probably will even be a lot of breaking news, live coverage here that we will be bringing to you on Tuesday and perhaps even Monday as we learn more information. Make sure you subscribe to the MeidasTouch Network. It's free to subscribe to our YouTube channel. If you watch this on YouTube, be sure to subscribe on audio as well, wherever podcasts are available. Just search for Legal AF and subscribe and leave a 5-star review. If you listen to this on the audio feed of Legal AF, make sure you search on YouTube and subscribe to the MeidasTouch Network, where you can get all of the video of these episodes as well. Check out store.MeidasTouch.com for the best pro-democracy gear out there. That's store.MeidasTouch.com. We have Legal AF gear. We have Convict 45. We have No One Is Above the Law gear. Some great timely stuff. Store.MeidasTouch.com. I think as the indictment was released, our producer Salty cooked up some new designs that were very relevant. That's store.MeidasTouch.com. We'll see you next time here on Legal AF. Always a pleasure and honor to be with you, Legal AFers, you, Michael Popok, Karen Friedman Agnifilo. We'll see you next time on Legal AF. Shout out to the Meidas.